My name is Michael Gallagher. I am the former director of Euro College, Tartu University, lecturer of European law, and former director of the Estonian Law Center, which is a judicial training institute here in Estonia. And I'm here to talk about the legal dimension of the crisis facing the European Union. And I'd like to do that especially from the perspective of Estonia. So in order to do that, we might get started by taking you back to the year 1991. Before 1991, Estonia existed as an administrative unit of the Soviet Union. This meant that Estonia did not have a separate legal order, but that all of its laws and legal institutions functioned within the Soviet legal order, which, by the way, was very different. It's very different than European legal orders. The main reason is that the Soviet law is an expression of Soviet ideology. The idea being that ideology was correct, right, and so therefore all that law really needed to do would be to make sure that the legal decisions that were made did not in any way get in the way of the implementation of this ideology. Suddenly, and to everybody's surprise, in 1991, the Soviet system collapsed, disappeared, and Estonia became independent once more. Well, everybody celebrated. This was a tremendous achievement, but at the same time, there was a big challenge, and people began to realize that this challenge was not simple to overcome. That challenge was, how do you re-establish a legal order? How do you make a state function once again through its legal institutions? You might be surprised, but there are no manuals or textbooks that tell us how to do this. And you might be surprised when you hear that around the world, quite a few states are called failed states. In other words, the general idea or the general conclusion is that the legal order does not really function. So in 1991, 1992 in Estonia, we were acutely aware that we needed to avoid this result. We needed to have a successful state. It's not many times in the world that a state gets a second chance to be independent. So we wanted and we needed to make this work. But how to do it? Well, I would like to address this question in terms of what makes law legitimate. What gives law its authority so that people actually obey it? We can start from the proposition that law is not something that you could just make in your basement and expect people in your community to be loyal to the laws that you would like them to follow. Law requires a certain framework before it works. What does that framework look like? Well, historically, law derived its authority from God. This is the Western idea that God directly conferred authority upon a person. And that person embodied the authority of God. So the king or the pope had the authority to delegate from God, and that delegation made the legal system work. And this worked quite well, relatively speaking. It worked well until there was a competing claim during the Protestant Reformation that God conferred authority on a totally different set of institutions and people. Now, both of these legal orders had a universal idea that God only did this conferral once. And so Europe plunged into religious war. And this religious war was truly terrible. The solution was to take a step back and accept that the legal order would not be universal. In other words, the states that accepted the authority of God through the Pope would no longer try to impose that on the states that had a Protestant legal order. But it still adhered to the idea that the authority of the legal order was based in what is right, preferably right and conferred from God. If we think about this going into the 19th century, the urge to legitimize law based on what is right led to what we called the legal science movement. Legal science asserted that it was possible to come up with a perfect legal order or perfect set of laws. Well, this first idea, before the legal science movement from the Napoleonic Code, we have German legal science with the German Code. These are attempts to create a legal order that embodies the best principles possible. And if they are the best principles possible, there is no basis to contest the legitimacy of the system. While we still adhere to this to a certain degree, the whole idea that this could justify law completely was challenged. And it was challenged in a way that still the challenge has not been put down by the legal realists in the 1920s. The legal realists argued that it is simply not possible to claim that a system of law delivers right answers for the people all the time. Law makes mistakes. Law can do terrible things. And when you focus on what effects law has on people, then you see that law often is used by people in power to stay in power rather than to enhance community. So the legal realists argued that wouldn't it be better if law was legitimized because of its effects? And one legal realist by the name of Carl Llewellyn wrote a book which I think illustrates this idea quite well. And I think it illustrates it in a way that's important for us when we think about European law. The book was called The Cheyenne Way. And into The Cheyenne Way, Llewellyn posed this question: is it possible for a legal order to exist when a community has no written language? And so there can be no rules. There can be no conferral of authority by written word. The Cheyenne tribe in the United States had no written language, and so Llewellyn studied them very closely with sociologists, and they came up with two conclusions. The first one is that they had a legal order. People were loyal to the legal system. They followed the authority of the tribal elders. The second conclusion is a bit astounding. That conclusion was that the legal order of the Cheyenne, in some ways, was more nuanced than the legal order of the United States of America. And the reason was quite simple. That reason was that the Cheyenne elders made all of their decisions with the idea that the decision should enhance the community, strengthen the bonds of the people to the tribe. And every decision was made for that purpose and was made in that way. So we might compare, for example, in Western tradition, in Europe and the United States, we have the idea of compensation as a remedy. And it makes sense for us to say, if I suffer a wrong, someone breaches a contract or hits me or injures me in some way, that I should be compensated. I should be put back in a position as if that this injury had not happened before the injury took place. For the Cheyenne, this would not make sense. They'd say, well, what effect does your injury and the causation of your injury have on the community? And this would be what they want to cure. It may be that I would be given something more than compensation, but certainly whatever the remedy would be community-oriented. Now, I'm not advocating that we adopt to Cheyenne legal thinking, but I do want to highlight it because it brings out an important aspect of legitimacy of law that now is, to a certain extent, accepted by legal theorists, at least in part. At least we can say that the challenge made by the legal realists to legitimacy thinking has not been dismissed. It's still a vibrant way of considering what makes law legitimate. So going back to Estonia, we had to answer this question: what would make Estonian law legitimate? For us, we felt we made a strong assertion of what's right in the Constitution of the Estonian Republic. In addition, going forward to 1994, there were great concerns about whether the legal institutions here were meeting the expectations of the Estonian people. Opinion polls, for example, back in 1994, showed that the courts were held in relatively low regard. Now, for us, and thinking about this in terms of legitimacy, this is a serious problem because it shows that people do not believe that the courts were enhancing their community. And so there was quite a lot of talk back then about how can we improve this. And we spent a tremendous amount of time and effort to, first of all, make judges aware of this as an obligation of the court system to meet the expectations of the Estonian people, and then to offer tools to raise the performance of the courts so that we could strengthen its position within the community. And I think these efforts were successful. They were necessary, and they worked. Now, the key lesson then going forward is we acted upon what we saw was a needed strengthening of the legitimacy of the local system. Now, at some point in the mid-1990s, we began to think about joining the European Union. And one aspect of this is that we had to take over a new legal order. So we had to take a look and see what does it mean to take over the European Union legal order. Well, it's treaty-based, and a treaties being agreements between states means that the European Union piggybacks on the legitimacy of the legal order of the member states, which is okay. But we also have doctrines of European law which were a bit more troubling. For example, supremacy. Supremacy is a legal doctrine of European law. It's made by the European Court of Justice. And the supremacy doctrine says that in order for the European Union legal order to work, to function, European law must be supreme over local law. In other words, local law cannot trump European law. This makes sense. If you're trying to build a single market, you cannot have each member state interpreting European law differently or not applying it at all. European law must be given effect if the European Union mission of creating a single market is to be achieved. It's a completely logical idea. But at the same time, the Court of Justice applied the supremacy doctrine also with respect to the constitutions of the member states. And the European Court of Justice asserted that European law is supreme even with respect to constitutional law. Well, keep in mind that the constitution of a member state is the deepest commitment to what is right. it legitimizes legal authority, and to the extent that European law is going to trump the Constitution, it should have a strong basis in legitimacy. Well, unfortunately, it did not. European law is functional. It is designed to meet the agreed aims set forth in the treaty structure. So we are left with the idea that to the extent that the European project works, we can accept the relative weakness of European law in terms of legitimacy. And this was the state of affairs for many years, where member states pretty much accepted the European legal order. The challenges that it made, that were made to the legal order were met. And the European legal order did not attempt to move too quickly so that it might create issues for member states to accommodate what it was trying to do. And that was the state of affairs until we come to the year 2008. And the global financial meltdown created a relatively huge storm for Europe. Now, when we talk about this crisis, we should make clear that the European Union did not cause the crisis. This is not a crisis that we can blame on the Euro or on the Commission or the European Court of Justice or any of the European institutions. At the same time, it is a serious crisis because the crisis calls into question whether the Eurozone or the European Union currency can be sustained, which, by the way, is a complete surprise for everybody. I can remember well before Estonia joined the Eurozone, we were considering what it would mean, and we had a conference. The Euro College of Tartu University sponsored an international conference where we invited central bankers to come to Tartu and to discuss what are the risks that Estonia might face if we join the Euro. And unanimously, the central bankers said there are none. The Euro is solid. As long as inflation can be controlled, there will be no risks for joining the Euro. Well, I mentioned this once again to bring out what a surprise it was after the financial crisis hit that the Euro did have problems, that there were internal policy problems in how to maintain the Eurozone, and indeed whether maintaining the Euro was the best policy option. So this was certainly a crisis. Now, while the European legal order did not cause the crisis, to the extent that it can maintain its claim to legitimacy, I would argue that the European legal order must address the crisis and find a solution to it. Now, that solution can be based upon a right, some sort of principle that joins us together, or in terms of the legal realist thinking, some sort of way to enhance community. To date, I would argue that neither has happened. So the question arises what to do. Some have argued that, well, maybe we have reached a turning point and perhaps there should be some stepping back from the legal order to weaken it further, to make it the European project more limited. I'd argue that at this stage, I don't think this is possible because European law has become a fact of life for managing the affairs of all of the member states. But I would argue that the crisis needs a rethinking of what legitimizes law and a strengthening of that basis. How to do that? Well, we go back to the same challenge that we faced in Estonia back in 1991. And as we look at this, we might consider other historical examples. For example, the United States. And the United States faced an incredible challenge to the legitimacy of its legal order back in 1860, just before the American Civil War, when the southern states asserted that the legal order would no longer apply to them. They were seceding from the Union and setting up an entirely new country. After a terrible war, President Lincoln addressed the question about legitimacy of the American legal order. Before the war, the American legal system and its constitution was primarily a pragmatic compromise. It was a compromise that balanced the need for a central government with the need for states' rights. And indeed, you could think of the original idea behind the constitutional arrangement was to ensure that European states would not militarily take over the colonies or take over the United States once again. So the original legitimacy idea was actually relatively weak. But Lincoln asserted there's a much stronger basis for legitimacy. He said that the United States is a nation dedicated to the principle that all men are created equal. It's a very interesting formulation. The idea that a nation is dedicated to this principle of equality makes a strong assertion that it's dedicated to something that is right. Now, that this is a country that can assert it's different, it's unique, it's special. This is what makes us a people. The fact that we are dedicated to this says we may not have achieved it yet, and we may actually never achieve it perfectly, but we are committed, and the legal order is committed, to continually strive to make progress in these areas. And indeed, after Lincoln made this proclamation, nothing really happened for nearly 100 years before the United States and its legal order addressed the idea of segregation, voting rights for blacks, and then later equality between men and women, and now equality between gay and straight people in marriage. I would argue, though, that this formulation being dedicated to the principle has had a powerful strengthening effect on the legitimacy of United States law. By the way, as an aside, it also has created a political agenda, which we see from the Civil War all the way to the present. The second re-legitimizing effort in U.S. law was to ensure that local people had access to legal remedies. And so the idea that even if you are not in favor of a particular U.S. law, you have the opportunity to assert a local challenge to it, both in terms of local democracy and in the courts. So this, by the time the legal realists came to think about legitimacy, was a basis that they said, aha, you see, courts can be very useful here. And American legal thinking embraces this idea. So there are two ways that the American legal system has strengthened legitimacy: an assertion of right, embracing right, and access to legal remedies. What about Europe? Can we learn from this? Well, I would argue that we need strengthened legitimacy of European law, and we might find it by embracing a principle, embracing principles that make Europe unique. Well, Europe has many, many principles in the European Convention of Human Rights and also in European law, but it is not a system that is logically flowing out of a single principle, the way Lincoln asserted the United States legal order flows from a dedication to principle that all men are created equal. Lincoln's idea did not come out of thin air. He went back to the reason why the United States was created. And that reason was colonists felt they were not being treated equally to British citizens. So if we look at what Europe should embrace, we might go back to the time when Europe was formed. The European Union thinking was started after the Second Great War. What was it about that experience that changed Europe profoundly? I would argue that we can look at two elements there that are particularly important. One was the inhumanity of the war, the terrible inhumanity of the legal systems before the war was recognized as something that should never happen again. And so I think there is room to strengthen the European legal order by dedicating it to a humane approach to legal authority. Europe as the humane authority of the world. But in addition, I think Europe should rethink whether its assertion of a right or rights, as I proposed, is enough. Whether they should also think about whether European law should be legitimized in how it affects community. And this is a bit troubling because we admit that there is a democratic deficit in Europe. This should be rethought, I think. European law should be enhanced or enhance local community. That means European law should address the concerns of individuals. We attempt to do this to a certain extent in subsidiarity, but I would argue subsidiarity is too weak an idea. I would propose instead that using Article 6 of the treaty, we enforce the respect to local democratic tradition that should be a foundation of European law by providing a tribunal at the local level where individuals can assert challenges to European law based on the idea that it violates local democratic tradition. This would be a new institution, a new institutional arrangement, a new way for bringing law into the European legal framework. It would also mean providing a new remedy, and as we use our legal realist thinking, providing remedies is a key way to enhance the legitimacy of the legal order. Would this work? Well, I do believe it is a precondition for the European legal order to get beyond the current crisis. I do believe that stronger authority is needed, but if European law is to be asserting stronger authority, it needs a stronger basis to assert it. What effect would that have here? Well, first, we might consider where we are at the present moment. European Union membership has given Estonia tremendous benefits. There's no question. At the same time, because so much authority has been conferred to European institutions, I would argue that membership has weakened the Estonian legal order. It has taken away a certain amount of creativity in law preparation, legal thinking, and it has also perhaps put an outer limit on the idea of the role of courts. And so I would argue that there are some negative aspects to membership here when we think about the ongoing need that the Estonian legal order should be further enhanced. These ideas that I proposed here for embracing our dedication to a principle of humanity and to opening a new tribunal for access to people, for people to challenge European law, I think both would benefit Estonia. Looking at Estonia's history, we very much need to be part of a more humane legal order. Estonia suffered terribly in the Second War, and it suffered for 50 years of occupation and imposition of a foreign legal order. For us, this idea that we're part of a new framework where humane principles govern, I think would be embraced. And I think it would have a positive effect on the Estonians embracing Europe and then embracing their own institutions as part of Europe. In addition, having a new tribunal where Estonians could assert their local democratic traditions, I think could have a positive effect on the idea of guaranteeing local remedies for problems. And if there are remedies, then people will take advantage of them. So I believe that this way forward would be beneficial and most likely accepted here as well. So while Europe faces a serious crisis, and while that crisis is likely to persist, and while there are no simple solutions to this crisis, I believe there are ways forward, that the European project can and should go forward. It should go forward with strengthened legitimacy of European law. Thank you.